A warm welcome to Bentham House, home of the Faculty of Laws at University College London. For those I've not met, I'm Stephen Vaughan, Professor of Law and Professional Ethics in the faculty. We are delighted to have Brad Wendel here this evening to talk about his book, Cancelling Lawyers. And we're very grateful to the Centre for Ethics and Law at UCL and to Kingsley Napoli for being so generous with co-sponsoring this event. We have questions that Julie Norris and I will put to Brad. I'll do some brief introductions. We'll then open up after our panel discussion for audience participation. I can see many of my own students in the audience, so if it is a little silent, I will be calling on you. And then we move outside to drinks at 7:15. This is a very popular event. We had more than 200 people sign up for the in-person and online lecture. So really delighted that it's taking place. I imagine there'll be a very lively and spirited discussion this evening. And my only hope is we don't move from cancelling lawyers to cancelling academics. So some brief introductions. Brad is a lawyer and philosopher, the Edwin W. Woodruff Professor of Law at Cornell Law School, his academic home of the last 20 years. Before entering academia, Brad clerked for Judge Andrew J. Kleinfeld on the U.S. Court of Appeals for the Ninth Circuit in Fairbanks, Alaska, and practiced as a products liability litigator in Seattle. He does lots of work away from Cornell, among other matters, serving as co-reporter for an ABA Ethics 2020 Commission, co-chair of the New York State Judicial Task Force on Attorney Discipline. He is very much one of the world's leading lights on lawyers' ethics. I saw a lovely thing on Twitter the other day, which said, we say a lot that academics are leading in their particular areas, but not necessarily where they are leading us to. LinkedIn also reliably informs me that outside of work, Brad is a pilot and co-owner of a Cirrus SR-22, and here I quote, an aspiring aerobatic pilot. Julie Norris, to my immediate right, is a partner in the regulatory team at Kingsley Napoli. She acts in the professional practices sector, advising lawyers and law firms on regulatory compliance, investigations, adjudication, enforcement, and prosecution. And Julie is listed in the top bands in her practice areas in multiple directories. She spent a number of years on the City of London Law Society's main committee as a member and is currently on the task force on business ethics and the profession. She is a champion for workplace disability inclusion and vice chair of the firm's Enable Group. I sadly could find no information on LinkedIn or elsewhere about Julie's aeronautic acrobatic skills. So I'll hand over to Julie. We're going to pass back and forth in our conversation with Brad.
Thanks. Nice to see everyone here in person and online. I'm going to start actually with the image in your book on the front cover and ask you what the inspiration was for it and where it came from.
Well, the Cancelling Lawyers title, I'm normally pretty bad with titles, but I'm kind of happy with this one. I've just been immersed in this awful discourse in the US about cancel culture, which is incredibly frustrating. But this book grew out of a paper that I wrote called Lawyer Shaming, where I was talking about the phenomenon of directing this sort of ire and social media campaigns against lawyers. And it got me back into some old debates in theoretical professional ethics that I had read since graduate school and written about. And it made me realize that we still had a lot to say about this debate, which seems to sort of go round and round in a frustrating way. And nothing seems to go round and round in a frustrating way like cancel culture and that term. And it's slung around as a term of abuse by both sides in at least our political culture. I hope it hasn't crossed the Atlantic to you guys. But on the right, it often is a way of shorthanding a kind of progressive intolerance or illiberalism, and it refers to trying to deplatform speakers or shouting down people with unpopular views. And lately the right in the US has sort of seized the mantle of free speech. We're pro free speech, and I don't think the left has done a very good job of responding to that. On the cancel culture thing, the left says, oh, it's actually not cancel culture, it's accountability culture. That's their little rhetorical move, and there's something there, I think. which is that a lot of these practices of calling out and shaming and organizing social media campaigns and things like that traditionally are a weapon of the less powerful or the more marginalized voices in society. It's, something that you can do when, everyone else has access to the levers of power. One thing you can do is to deplatform or shout people down or shame them or something like that. And there's a sense that a lot of the lawyers who come in for this sort of cancellation are themselves the agents of powerful instrumentalities that are sort of hard to fight back against. And so I observed this tendency in the public criticism of lawyers, and I kind of analogized it to cancel culture and, tried to use that to make progress in the debate. And the label of accountability culture actually helped me link this annoying public debate to something that's actually fairly important in moral philosophy, and maybe we'll talk about that a little bit. I tried to write a book that is simultaneously accessible to regular folks and also theoretically sophisticated so that moral philosophers will read it and think, there's something there. Now, that's a disaster from the point of view of an audience management strategy as an author. Let me tell you, don't ever try to write 2 books at the same time. It doesn't work. Maybe it does, I don't know. But I tried to have these alternating chapters where I would talk about a case study of cancellation or criticism of lawyers, and then say, what philosophical lessons spin off from this? My wife said it's like, here's the fun part, here's the homework, here's the fun part, here's the home. So that's the risk. But the idea of accountability culture helps link up with accountability and moral philosophy. So that became a theme of the book.
I would say it does work.
Oh, thank you.
Because what you've got is you've got a case study which brings it to life, and then you need the theory. So you get the nice fun bit, and then you get the hard bit, but then you link them together. So it does work. And one of the really interesting case studies that you deal with is first in the book, and it's about Cravath. And I know certainly when I read it, I was interested in the debate around whether or not they ought to have acted. But for those that haven't read it, might you explore that a little bit and explain what went on?
Sure. And I started with that one for a reason. And one reason is it's not a criminal defense case. And so one of the things that I encountered when I was talking to people about this book, Public Criticism of Lawyers, oh, you mean defense lawyers who are asked, how can you represent people who you know to be guilty of terrible things? And I said, no, actually, that's not predominantly the focus of the book, in large part because I think the public more or less gets that. They kind of understand the case for treating the accused with dignity, running a fair process, checking government power. That's, at least for us, enough baked into our public discourse and the constitutional rights of criminal defendants. People watch endless amounts of cop shows on TV, and I think they sort of get that. That doesn't seem like a hard case to make. The harder one, and there's a question later that I think Stephen's going to talk to me about the justification of lawyers acting for companies in counseling and advising context or transactional practice. That's in some ways a little bit more tenuous. And so the Cravath case I liked because it's a civil litigation example. And it arose, so Cravath is this big fancy law firm in the US, one of the most prestigious firms in the country. And they were asked 20 years ago now, 25 years ago maybe, to act on behalf of a Swiss bank, Credit Suisse, in Holocaust reparations litigation that had been filed in American courts. And some very good lawyers had figured out a theory of liability and jurisdiction that could center this litigation in the US. And it basically was brought on behalf of families of Jewish victims of the Holocaust whose family assets had been looted by the Nazis and then laundered through Swiss banks. And Switzerland had this very ambiguous policy at the time toward Nazi Germany, and Credit Suisse and other banks were more than happy to take these deposits. And so now the question comes up, what do they owe by way of reparations? Anything, fair value, what is it? And so they needed counsel in these very complicated proceedings. Credit Suisse went to Cravath, outside counsel who had acted for it in the past, said, will you represent us? Cravath management said, sure. This led to a revolt by junior associates in the firm, many of them Jewish, but not all. And they wrote this memo to firm management saying, what in the world are you thinking? We're taking the representation of a Swiss bank in Holocaust reparations litigation? No, we can't do this. And to the great credit of firm management, they said, okay, let's slow down a bit. And they had this interesting consultation process. They brought in leaders of the Jewish community. They consulted with rabbis. They said, what should we do? And they came to an interesting conclusion, which is they would go back to the client and seek the client's informed consent to a style of representation that would be less than the full-on Cravath treatment. So this firm and many other New York City law firms is famous for a kind of scorched earth style of litigation, which is delay, 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 take discovery, take 1 million depositions, slow things down. That's why you hire Cravath. It costs a fortune, but they slow down litigation. And the firm said, we'll go back to the client and say, we will help you administer a fair process. We will help you design this, but we're not going to resist the basic justice of the claims asserted by the plaintiffs in that case. Are you okay with that? And the client said, sure. So I like this case for a lot of reasons. One of those is that it's sometimes easy for lawyers to write off public criticism as uninformed. You non-lawyers, you're not steeped in the arcane mysteries of the law. You don't understand what we do. How dare you criticize us? These are lawyers who are raising this criticism. These are very smart lawyers. It's hard to get a job at Cravath. And they were perfectly well aware of the long professional tradition of representing unpopular clients, the importance of counsel, due process of law. They get it, but they still said, we think there needs to be more said here. We think there's a justification that's required over and above the legal right to counsel or whatever. And again, to their credit, firm management took that seriously and slowed down the decision-making process, thought about it a bit. And that's one of the themes of the book, is the recognition of this tension between what one is professionally permitted or obligated to do as a lawyer and what one as an ordinary human being, moral agent. That tension sometimes is possible to resolve, but sometimes it's not. And what happens when there's that tension could be a slowing down of the process a little bit, a modification of the representation, an awareness of the complexity of these issues. And I think the Cravath and Swiss Bank example shows that really nicely.
Cravath at all times acted consistently with their professional
They did. They did.
Can I pick up on that non-accountability
Mhm.
point? Because it's in the homework chapter of this case study that you begin to explore this emerging view about lawyers perhaps needing to be accountable. And we set that against the sort of standard conception model of non-accountability. And you introduce a phrase, let me just get it right, about the fact that morality is fundamentally relational. And that's when you're talking about this accountability point. Can you share a bit more with us about that and where you reached on that?
Sure. Yeah. And this is the homework. And it's, related to one of the aha moments that I had in writing this book. I was reading some relatively recent work by Tim Scanlon. He's got a book called Moral Dimensions, and there's a chapter in there on blame, which is really good. And the title of the book, Moral Dimensions, I think gives you some idea where this is all going, which is that morality is about more than just permissibility. It's more than just, pure practical reason, as Kant would say, or since we're in Bentham House, the greatest good for the greatest number, There are a lot of ways of thinking about morality, which are just in terms of the permissibility of actions, where that's understood in a fairly abstract way. And the relational way of thinking about morality grows out of a famous paper by a British philosopher named Peter Strawson called Freedom and Resentment. And there's a lot going on. It's a very thick and rich and interesting, chunky paper. There's a lot going on there. But one of the things that comes out of Strawson's paper, and there's now a whole post-Strawson line of philosophy, is that responsibility, moral responsibility, doesn't follow after a conclusion reached on the basis of pure reason that one has acted wrongly. That's not the right way to think about it. Rather, responsibility is constitutive of morality. In other words, the experience of being a human being in a relationship with other human beings, in a practice of acting and responding to demands for explanation and justification and explaining oneself and justifying, and sometimes engaging in these sort of angry processes of blame or resentment or irritation. Strawson calls these reactive attitudes. He says that literally is morality. It's not some epiphenomenal thing that has to be explained. It's what morality is. And this has led to post-Strawson literature, which is quite interesting. And modern philosophers, Tim Scanlon, Stephen Darwall, Jay Wallace, Susan Wolf, have written, really illuminatingly about this. And what it helps do in the theory of legal ethics, I think, is bring in addition to the perspective of lawyers acting in role, who have obligations as a matter of the rules of professional conduct, but also the normative structure of the role. In addition to the role, there's what follows from being a human being in relationships with others. So in the Cravath case, there are the lawyers who say, I have obligations to the Jewish community. I have, relatives who are Holocaust survivors. What am I to do with that? That's a relationship. And there are lots of these cases in the book that deal with people who have relationships with individuals and communities beyond being just a lawyer. And the question is, how does that come in? And the answer is, it's not a mysterious thing from the point of view of morality. It is morality. And so that's the relational dimension of this. And yeah, it's one of the homework chapters.
I'm going to jump in now, bring us back to one of the other case studies. And so we're sat in a university, and one of the other case studies is about Harvard and about Harvey Weinstein and Ronald Sullivan. What went on there?
So yeah, this is always good in law schools to mention that one of the canceled lawyers or criticized lawyers is a law professor. Ron Sullivan, a famed civil rights litigator. He is well known for a number of representations, including that of the family of Michael Brown, who was killed by the police in Ferguson, Missouri, and became kind of one of the early Black Lives Matter, cause celebs. And Sullivan was right there. And there's no question that he is a dedicated civil rights lawyer. He's also a professor at Harvard Law School. And in addition to that, he has an administrative role as an advisor, mentor, counselor type person in one of these Harvard residential houses. So Harvard and Yale and a few other US colleges have something like the Oxbridge system where you live in a college while attending Harvard University, and there are faculty supervisors, but just sort of mentors and advisors who hang out with the students. Sullivan was one of these people. So along comes the criminal prosecution of Harvey Weinstein for rape in New York State Court, federal court, no, state court. And Weinstein tries to assemble a defense team, asks Ron Sullivan, will you represent me? This is not an appointment case, right? Just to situate this in the US context, we don't have anything like the English cab rank rule. And I understand that's just, for barristers. And I understand, according to folklore, widely circumvented, but it's at least part of the ideology of the British profession in a very important way. The idea is that we're just taxis picking up the next passenger at the queue. There's nothing like that in the US. There are lawyers who are publicly employed as defenders, and they generally take all comers. Sometimes lawyers will agree to be on a role of counsel to be appointed by a court in certain cases. It's really unusual. Overwhelmingly, in almost all cases, American lawyers have complete discretion to choose to represent a client or not. And this was one of those cases. Ron Sullivan decides, yeah, I'm on the team. I'm going to be on Team Weinstein. And he was completely unprepared for the gigantic public controversy that ensued. I guess he's unfamiliar with universities, but he seemed blindsided by the students being outraged by this. How can you represent Harvey Weinstein? And what I found so interesting about I love this case. I keep going back to it. What I found so interesting about the case was the talking past each other of Sullivan and his defenders and the critics. The debate just was not joined. And so Sullivan talked a little bit. He gave an interview to the New Yorker magazine, which I'm sure he later regretted. And various faculty colleagues of his at Harvard and lawyers at other law schools came to his defense. They said the standard stuff. And, there's almost a push the tape recorder and play the same old debate. They said the same stuff that lawyers always say. Everyone's entitled to a lawyer. The American profession has a long and proud tradition of representing unpopular, reviled, whatever clients. We think this is an important check against state power. It's not for us to decide whether our client is bad. That's the sort of thing that is going to be decided by the judge in litigation. All of the same old, everyone deserves a lawyer kind of arguments. And the response to this was, Yeah, we know. You're not telling us anything we don't know here. What we're wondering is, why do you want to do this? We understand why a lawyer could represent Harvey Weinstein, or no one's denying that he has a right to counsel. But the question is, we want to know about your humanity, your moral agency, your Ron Sullivan-ness. How do you square the commitment to civil rights, which you fought for your whole career, with working for that guy? How do you square speaking of relationships and accountability, how do you square your responsibilities to the students under your care and concern at Harvard, the undergrads who you serve as a mentor to? How do you square your responsibility to them, some of whom will be survivors of sexual violence and will not be at all happy to know that you're on Team Weinstein? What do you do here? And Sullivan and his defenders, I think, just didn't hear the moral dimension, to use the Scanlon line, or the moral register that this question was being asked in. They kept responding as though sort of asserting the professional role was a sufficient response. And I think they were mystified that it's not a sufficient response. And that's actually one of the major takeaways from the book. After spending 18 months or whatever immersed in this, one of the things that really struck me is that for outside the profession criticism of legal professionals, they understand the standard case. They just don't think it's sufficient. They want to know more. And so in the Weinstein-Sullivan chapter, I suggested, purely fancifully, I had a very brief email exchange with Sullivan, but he didn't answer this question. Purely fancifully, I suggested there are a number of reasons he might give if he were to explain himself. Not saying he has to, but he might say, look, I'm a criminal defense lawyer. And one of the things criminal defense lawyers love is a challenge. And this case would be a challenge. This would be like a professional Mount Everest defending Harvey Weinstein. How could I turn down the chance? This is going to be sophisticated prosecution and defense and smart lawyers, and everyone's going to be going all out. It's going to be great. He could say that. He could say, for my whole career, I've stuck up for the underdog. And I know Harvey Weinstein, rich white guy, doesn't seem like anyone's definition of an underdog, but notice how he's faring in the court of public opinion. Everyone's already prejudged his case. I actually, in a weird way, feel kind of sympathy for the guy. He could say that. He could say, I got a bunch of boat payments to make, and there's nothing wrong with earning a living, right? So maybe I can subsidize some of my other pro bono civil rights cases that I do. Who knows, right? And I don't know if any of those things would have appeased his critics, but these are things that one could say. And people sometimes misread the book as I'm calling on lawyers to make an actual explanation for themselves. And I understand that lawyers are bound by duties of loyalty and confidentiality and often can't say anything about their clients' cases. And that may actually feel unfair to them. Like, I can't respond to critics. Yeah, maybe you can't. But the sorts of things that the students seem to be calling on Sullivan to say are the sorts of considerations that I think lawyers need to take into account and be prepared to answer for themselves as moral agents. And by doing that, we can help insulate the professional role from what otherwise could be a quite coercive tendency, corrosive tendency with respect to moral agency. It's possible to kind of, it sounds like a bit of an exaggeration, but lose your humanity a little bit in the professional role. And I think being alert to the kinds of things that the student critics were asking Sullivan to say can help prevent that sort of slide into complacency.
Let me come back to sort of standard tape deck point you made. Why represent Weinstein? Well, states prosecuting, consequences, incarceration, unpopular clients. Even who might disagree, I think generally there'd be some level of agreement that lawyers representing criminal defendants or those accused of serious crimes kind of makes sense. And you kind of get into that in the chapter that follows from the kind of case study. But what about the flip side? Is the consequence of that the arguments for representing corporations in non-criminal contexts are less strongly justified?
Yeah, so I like your question about weak and strong justification, and that's one of the things that I wanted to do in the book is to a little bit shake up these kind of strong dichotomies. Like, it's either fully justified or not, on, off, yes, no. I want to suggest that there's a dimension of strong and weak justification, but I also do think the representation outside the criminal defense context and the adversarial litigation context is equally justified. Professor Vaughan just led on that he's in his class, if you're in his legal ethics class, reading a book that I wrote a while ago called Lawyers and Fidelity to Law. where I tried to make the case for lawyers' role morality, for what lawyers do in their role, and to do that in moral terms, to do that in a way that makes sense in relationship to their moral agency and their responsibilities to others. And the basic outline of the argument builds on the adversarial example. It builds on litigation, but it doesn't see litigation as the ideal. It's maybe an ideal, but it's not the only thing. So I had another one of these aha moments when I was writing the book, Lawyers and Fidelity to Law. And it came from another English philosopher, as it happens, Joseph Raz. And Raz has this great illustration where he says, imagine there are two parties and they're in a business relationship in some way, and they find it mutually advantageous to be in this relationship. They don't want to rupture it, but there's a dispute. Maybe one of them says your delay of widgets was delayed, was untimely, or they're defective or whatever, and they fight about it. And there are factual uncertainties and there are values in dispute and they can't go on. What do we do? So Raz says, what do you think reasonable people in that position would do? They would appoint some third party, some neutral. They'd find an arbitrator. And they would say, hey, arbitrator, we'll make our case to you and you decide, and then we'll go on. And then we will resolve this little rupture and we'll move on with our mutually advantageous relationship. So the Raz thing, it really was a massive, wake-up call for me. There's a simple takeaway from the Raz story, and there's a fairly deep one. The simple takeaway is you can generalize this to all manner of disputes, including massive society-wide disputes about what rights people ought to have, what duties people ought to have, how resources should be allocated, all kinds of things like that. Imagine that the two parties in the little tidy Raz example is all of us. We're all in this relationship where we don't really have an option of rupturing it. I mean, I guess you could leave your country, thought about it, believe me. But you really are kind of stuck with the fellow members of your political community. And you also, I mean, I suppose you could go to war with your fellow citizens, but I don't want to do that. And so you kind of are looking for a basis to continue this relationship in some way. And the arbitrator here is a metaphor for the legal system and the law and lawyers and everything that implements that. That's the fairly simple takeaway from it. The deeper takeaway, and this is where my position is kind of controversial in the literature, the deeper takeaway is Raz says it's important from the point of view of the parties that the arbitrator's decision replaces whatever they had as contending points of view going into the dispute. They have to agree that the arbitrator's decision will be a reason for them going forward. They can't go back and relitigate the dispute. Otherwise, there's no point in having the arbitrator. So again, by analogy, what we do as a society is we have all sorts of disputes about all sorts of things. So one of the examples in the book is law student boycotts of law firms representing fossil fuel companies, not in litigation necessarily, but in transactions and development deals and environmental compliance review and all the sorts of things that ExxonMobil and Chevron and those companies do. Not litigation, again. But so what's the dispute? The dispute, probably not even the reality of climate change or the urgency of the crisis, but what do we do in the transition to a decarbonized economy? We're not there yet. We can't get most of our energy from sustainable sources. So in the meantime, ExxonMobil or whatever still needs to enter into contracts and distribution deals and still has to do permitting and all that kind of stuff in order to provide the energy that we all need in order to live our lives. And we may disagree about all of those things, but I think we recognize that there is some value in having this framework of rights and duties and procedures that we can all use to organize mutually beneficial arrangements. And so, like the Raz arbitrator example, that kind of drops in and replaces the reasons that we had going into the dispute. It kind of preempts them. And that's the position I took in Lawyers and Fidelity to Law. It justifies, I think, the lawyer's role, not just in criminal defense context or litigation context, but also in transactional and advising context. But the thing that bugged me at the time and continued to bug me after the book was published is I think it squeezes out moral agency. I was really worried about it's, again, too strong of a dichotomy. The Raz arbitrator thing just kind of drops in. And there goes all of the other stuff that people might bring into the role. And that always didn't sit great with me. And so when I had a chance to work on Canceling Lawyers, I see it as sort of an amendment to my previous position. I still agree with the basic outlines of the argument in Lawyers' Infidelity to Law, but I don't think that the upshot of that includes non-accountability. I think accountability remains wide open, and we're accountable to the political community in the terms we always have been. It may not be fun to take that criticism. We may not like to have to deal with it, but it goes along with being humans acting in a role and being moral agents. And I think I needed to build that in to my previous position to kind of humanize fidelity to law, because otherwise people see that as a kind of one size fits all sort of robotic, like you get in this little Wendel lawyer box, and that's all there is to say about it. There's no more, no other moral dimension there. And I think that was incomplete. So in a way, this is like volume 2 of my work.
Can I pivot you
Yes.
onto another one of the central themes in the book? So moving away from accountability, but maybe using the scenarios that we've talked about already. You talk about blame and toleration and the interrelationship between them. Can you tell us what they are and how the concepts relate to maybe Cravath or Weinstein?
Yeah. So blame is a very interesting topic. It turns out there's a lot of really fun philosophy on blame. And I slightly depart from Scanlon. There's a paper by Susan Wolf called Blame Italian Style. My wife's Italian, so maybe that's why I like this. But she says it's more of an emotion than a reason. Scanlon sees blame as kind of an appraisal of the attitudes of another. So let me make this a little bit more concrete. He has a famous example where he says, imagine I have this friend, Joe. And Joe and I are friends. And I find out later that over the weekend, Joe had been at a party and was just running me down, just bad-mouthing me the whole time. Not a cool thing for Joe to do. What do? Says Scanlon. I adjust my attitudes toward him in response to what I take to be a deficiency in his attitude about our relationship. So being a friend means a lot of things. And one of those is having certain kinds of attitudes with respect to your friend. You stick up for them, you take their side, you don't run them down at parties. There are certain attitudes that are constitutive of this relationship. And there are times when people act in a way that is inconsistent with those attitudes and is inconsistent with the norms making up the relationship. And since morality is relational, one of the things that we can do as a practice to kind of sustain these relationships is adjust our attitudes toward others. So, for example, I'm going to kind of hold Joe at arm's length a little bit. I'm not going to trust him as much. I'm not going to share secrets with him. Maybe I won't be there when he calls and goes, hey, can you help me move? Sorry, I'm busy. That's an adjustment of attitudes. And that for Scanlon is blame. Now, it's a little bit of a cold emotional register, this adjustment of attitudes thing. Susan Wolf says, no, blame is more like, throwing things and yelling and being mad. However you characterize it, the important thing is it is a reaction to a rupture in a relationship. And it's a reaction to conduct that's inconsistent with the attitudes that are essential to the relationship. So the Weinstein thing and Sullivan is interesting because the major focus of the students' criticism was, we trusted you. We relied on you to be on our side, to have our backs, to listen to us. And the women students, and men too, but they said, I'm not sure I can open up to you knowing that you're on Team Weinstein. I'm not sure I can have the same kind of relationship of trust and confidence with you that I would otherwise. That to me strikes me as a just classic paradigmatic example of Scanlonian blame. And I actually just a couple of weeks ago had a little email exchange with Tim Scanlon. I sent him the book, and he finally got around to reading it, which is enormously gratifying for me because I'm a big Scanlon fan. And he said that he was at a dinner at Harvard Law School, or Harvard University in general, and the Sullivan case came up, and there was a big brouhaha about it. And he said, yeah, I see that. I see that as a paradigm of my account of blame. Now, he didn't say this because he's a really nice guy, but he might have said, I'm stretching that too far. I'm pushing it a little bit. Because for Scanlon, the relationships that matter are the more thickly described relationships that one can imagine with family, members of one's religious community, like Jewish associates at Cravath. There's a well-known example, which I can talk about later if you want, about a Black lawyer who represented the Ku Klux Klan in First Amendment litigation. He felt like he owed something to the Black community in his town to explain himself. What are you doing representing these guys? So, Scanlon would say that the attitudes that make up relationships, it starts to get too abstract if you talk about relationships that move out from this kind of thick core into thinner relationships. Now, other philosophers in this tradition, Jay Wallace in particular, talk about membership in the moral community. And Scanlon goes, that's too thin. That doesn't really do the work I want. He wants this to be about kind of concrete relationships. But it's interesting how often that recurs as a pattern in the criticism of lawyers. You owe something to another individual, community, cause, maybe. And that's where the rupture is. And we're criticizing you for doing that. That seems, I don't think it characterizes every one of these cases, but it comes up enough that it seems to be a pretty promising explanation of blaming behavior in these cases.
Thank you. Again, another pivot. You talked a little bit about the boycott of law firms and students protesting about big oil and representation by law firms of big oil. What do you think about the validity, morally or otherwise, about boycotts and protests in those forms?
Yeah, so I think the answer to that echoes the distinction at the beginning of like good and bad cancel culture. And one of the hallmarks of cancel culture in the bad sense, forget the left-right split, but you can see cancel culture in a bad way where it tends to be coercive and not persuasive. And the distinction here is the use of power as opposed to marshaling means of persuasion. So bad cancel culture is online mobs and things like that. A similar thing can be said about boycotts. So I wrote the chapter on the law student boycotts of law firms who represent big fossil fuel companies. There's a little mini brouhaha I don't know if there's a big and small brouhahas, but this is a smallish one because it only pertained to Harvard and Yale. But the students at those schools organized a group called Law Students for Climate Accountability. And they wanted to shame law firms who had a lot of fossil fuel clients and then urge shunning of these law firms by other students. Don't interview with Gibson Dunn. Don't interview with Paul Weiss because they represent Exxon and Chevron and these kinds of companies. Paradigmatic blaming behavior, right? Shunning and shaming are classic ways of expressing outrage, expressing resentment, whatever. So they tried to do this, and I had an email exchange with one of the student organizers of this, and I became kind of fascinated. And I wrote that chapter, and it got me thinking about boycotts. I really had never thought much about boycotts before. There's a rich and interesting literature on the ethics of boycotts. There's, by the way, an ethics of anything literature out there. But the ethics of boycott literature is really, really interesting. And the paper that really kind of unlocked it for me and helped me understand this is a paper by a Canadian political philosopher named Wahid Hussein called, this is a great title, Is Ethical Consumerism a Form of Vigilantism? Wow, and that's pretty strong, right? Vigilantism and private violence, but he kind of means it. And the distinction he's trying to draw there is between public and purely private ways of dealing with contested public issues. And he starts off by saying, and I completely endorse this, persuasion is all to the good. Anything that goes under the banner of a boycott or whatever, but it's just an attempt to persuade, awesome. And I agree with that. Law Students for Climate Accountability should publish their scorecard and shame Gibson Dunn all day long. I think that's all to the good. But when boycotts start to become coercive in the sense that they're an organized attempt to impose economic penalties on an actor without the kind of due process protection that we normally use in the legal system, then it becomes suspect for the mirror image reasons of why we care about due process, right? Why do we allocate rights and duties based on a system that has protections for the rights of the parties? Well, because we think it's important that both sides be able to present evidence, that it be listened to carefully, that there's an opportunity to respond, that there's an impartial decision maker who takes it seriously. These are things that constitute, I think the British term is natural justice. Americans tend to say due process. But these are kind of ethical principles that constitute what we do as lawyers. And Hussein's paper says the ethical issue with boycotts and the reason to analogize it to vigilantism is that the boycotters, the actors, are seizing for themselves the power to decide what's right and wrong, and the power to decide who's the good guy and who's the bad guy. He has another great phrase, although I love this paper. He calls it public interest anarchism. Like I get to decide what's in the public interest and you don't. And if you disagree with me, I'm going to, bring down all of this ruin on your business. That he says, what's wrong with that in ethical terms is that decisions are getting made about what's in the public interest and what consequences should follow from that based on one person's say-so and their ability to organize the opposition. And he says that to the extent there's an ethical problem with boycotts, that's the problem. Again, persuasion is all to the good. He's not saying that there's anything wrong with organizing people to come to dislike Gibson Dunn or whatever. And in fact, I think these law students, honestly, don't have the power to engage in the sort of behavior that Hussein is concerned about. There's all this concern on the right that these law student boycotts are coercive, and come on, we're talking about 10 students at a school, who cares? And they make a big amount of noise, but nothing actually happens. So I'm not actually worried about this, and I think most of these boycotts are just kind of noisy protest, and I kind of like noisy protest. But to the extent there is a problem with boycotting, it would be along those lines, I think.
We have time for one more.
Sure. Am I talking too long?
No, you're not at all. Can I ask it? Is that okay? Do you reach a view in your book? It's like you debate it at length on whether lawyers are doing enough to actively sort of engage with the ideas about whether they should be taking clients on. So whether lawyers are doing enough already in that regard.
Yeah, I don't know how much goes on at the level of a law practice or something like that to think about initial client selection decisions, but certainly lawyers now can't avoid this sort of thing. This is now part of contemporary law practice management. I was chatting earlier about a big law firm in the US, Kirkland & Ellis, who had a partner who headed up their appellate practice, former United States Solicitor General Paul Clement, one of the best appellate advocates in the country, definitely a guy you want in your law firm. But he had been representing a bunch of gun manufacturers in constitutional litigation after, any number of horrific school shootings in the US. And other clients of the law firm started getting worried about this. And they said, we don't want our firm taking on these gun cases. And so the firm went to Paul Clement and said, you've got to cut your clients loose. And he said, like hell I do. And he just left the firm and took his clients and formed his own little litigation boutique and wrote a really angry editorial in the Wall Street Journal. So I think this is the sort of thing that law firms are now having to be aware of. I do think the moral reflection thing is hard for lawyers. I used to, when my first school before I came to Cornell, I co-taught a class with a good friend of mine who's a philosopher on legal ethics. And we wanted it to be purely normative ethics. And his program brought in professionals in various disciplines to interact with the students in this weekend-long workshop. It was super cool. So he did doctors and journalists and lawyers, and I did the lawyer one with him. And we would call up the professionals and say, we want you to come in with an ethics case for the students to talk about. And the lawyers inevitably came up with some complicated conflict of interest problem. And we would say, no, that's not what we mean. And we keep going back to them and go, no, I don't care about Rule 1.6. Like, give me an ethics issue. And one lawyer said to me once, he goes, hang on a second. I think I know what you mean. Sometimes I'm just kind of letting my mind wander, like in the shower in the morning. I'm just kind of letting my thoughts drift. And I go, is there any good in what I do? Or am I just a sleazeball? Is that the kind of thing you mean? I went, yes, exactly. What is the case that makes you think about it in those terms? I think lawyers are habituated to turning all of these questions into rule of professional conduct. Well, there's an exception to Rule 1.6 and blah, blah, blah. I think they're just used to thinking about it in those ways. Lawyers are good at that kind of thing. It's comfortable. It's uncomfortable to sit in that spot of, ew. But so if there's any pitch in the book, it is for spending more time in that space of, I think it's actually really good and productive, although I completely understand that lawyers don't want to hang out there too much.
Wonderful. I think we should draw it to a close. I have the sense there are many other questions that will be asked during the drinks. Let me thank my colleague Christina and our events team for her wonderful support, and Brad for such an illuminating set of responses.
Let me add my thanks to UCL, to the Center for Ethics and Law, Kingsley Napoli. Thank you all very, very much for having me. This has been fantastic. Thank you so much.